Good morning, good morning. We will just give a few moments for a few more to join us. Good morning, everybody. Very good to see you here. Good day to you, wherever you're joining us from. It is 11 a.m. in Nairobi. And here we say karibu sana. Good morning and welcome to everybody who is joining us. Good morning, good day, wherever you may be joining us from. Thank you for logging in to the Law Firm of the Future webinar hosted by Mukiri Global Advocates. My name is Kezi Mukiri and I will be moderating this session. Please feel free to engage with us, introduce yourself in the chat box, let us know your name, let us know where you're joining us from. We're looking forward to an engaging conversation this morning. To kick off this webinar, we have an open poll, and you may participate in this poll by simply going to the poll section at the bottom of your screen, and you'll be able to answer the poll. We're publishing a poll, and please do go straight on to the poll area at the bottom of your screen. Let us know which category best describes you. Practicing lawyer, in-house counsel, academia, are you a student? Do you represent a regulator? Are you a client or a consumer of legal services? Do let us know which category best describes you. In just 30 seconds, 40 seconds. Thank you. I see about close to 20 of us have already polled. Thank you. Thank you for participating in the poll. And do kindly introduce yourself as well in the chat area. Let us know your name and where you are joining us from. This is the Law Firm of the Future webinar hosted by Mukiri Global Advocates, and we are indeed excited to be hosting this discussion today. Today's conversation does not focus on the technicalities of the law, but instead it focuses on the business of legal practice. The discussion today seeks to analyze the emerging trends in the delivery of legal services. We will look at the revolution of the legal practice, and we will make an attempt to forecast on the emerging opportunities within the legal profession and the legal services industry. Over the past decades, the legal services market has been changing, and this constant change has been driven by various factors throughout the years, right from the expansion of in-house legal department to globalization through mergers and outsourcing, to technological advances, and even the rise of alternative legal service providers. As advocates in Kenya, and even for us right here at Mukiri Global Advocates, we have been on a journey of building a legal practice that is customer-centric, efficient, and responsive to the constant changing market and industry dynamics. And today we are indeed very excited to have a great panel of speakers who will be sharing their experience and expertise with us. Without further ado, I would now like to move to warmly welcome and introduce our panelists today. At the very bottom of your screen, we have Caroline Kamende, who is the Vice President, Law Society of Kenya, and the Chairperson of the Africa Bar Association, Kenya Chapter. Welcome, Caroline. We also have Dr. Peter Kwenjera, who is the Dean, Faculty of Law at Strathmore University. Karibu sana, Kwenjera. In the middle section of your screen, we have Elisha Zebedi Ongoya, who is a Senior Lecturer, Faculty of Law, Kabarak University. And we have Christine Kahema Muthoi, lead consultant at Alpha Tax and Business Advisory Services. And right next to myself is Vincent Mukiri, who is the managing partner at Mukiri Global Advocates. So welcome very much to our panelists. Again, very delighted to have you here. I will ask, perhaps starting with you, Kamende, what current trends are you witnessing? Do you see a shift in the delivery of legal services in Kenya, specifically Kenya, but also across the African region? Do you see any shifts? If you could just give us your perspective, even as you make a broader introduction of yourself. Welcome.
Thank you. Thank you, Kezia, and good morning, everyone. I'm delighted to be here. Back to your question, do I see any shifts? Yes. In the advent of the COVID-19 pandemic, which has impacted many spheres of the human life, economic and social life, the question of law firms' sustainability has not been left out of question and discussion. That is what is happening to our businesses. So currently, now speaking as the regulator of the practice in Kenya, the practice of law in Kenya is regulated by the Law Society of Kenya, where I sit as the vice president currently. I previously sat there as a council member, Nairobi representative. What we have in Kenya is a limited space in terms of practice currently. We have seen tremendous, if I may say that, development of the practice of law in Kenya from the ages where we could not see new advocates who are admitted opening up their own law firms, to a space where we are in now that we have LLPs being regulated by the Law Society pursuant to the 2011 LLP Act. But we have not seen any development of the practice in terms of allowing parties and advocates in Kenya to register generic names and also partner with foreigners. So the Council of the Law Society of Kenya is the one that is mandated to regulate through passing of rules and regulations. We currently just regulate the opening of law firms through the limited space that we have in terms of statute, where we allow limited advertisement. You all know that you cannot advertise fully. There was a judgment by Majanja in 2011 that allowed the lifting of complete advertisement, ban on advertisement, but we have not seen any actualization of the rule that allows limited. We just see advocates writing an advocate, a notary, and a commission. We also don't allow, we only allow natural persons to register LLPs. We have not come to an era where we allow companies and other entities that are non-lawyers to practice and partner with law firms. So that is the current happening. Moving forward, I think with the digitalization pursuant to this COVID and the e-filing, and also the growth of the legal practice in the world, we may have to embrace technology and change. We may have to look outside the regulations that limit advertisement and incorporation of non-lawyers in our practices. That would be my opening remarks on that issue.
Thank you, Kamende. Christine, in your area of practice, do you see any shifts or any integrations or any kind of thinking that is moving away from the traditional law firm setup?
Thanks, Kezi, for that. The tax space is a very interesting space because it combines both government and taxpayers are actually mainly corporates or individuals. So what we are saying is that government is significantly under pressure to raise revenues because they are struggling to finance fiscal budgets. So that's what we are finding from a government perspective. On the other hand, as a result of their struggle, so they are coming up with tax laws that are becoming more complex, aimed at raising revenues from the already strained taxpayers. So taxpayers are having to experience increasingly complex tax legislation, penalties for non-compliance, economic disputes, and all these issues, they create the base for tax disputes. Yeah, gone are the days whereby government will say pay this and you as a taxpayer you just pay. If I feel that that's actually not how that law is supposed to be interpreted, I will challenge that. So we've seen a significantly increased number of tax disputes going to the tax tribunal and also to the High Court. So even as tax practitioners, we were mainly focused on compliance, and because of the systems that are coming in place both from taxpayers and also from the revenue authority, like with the iTax platform, that is something that anyone can actually do it. So there's a total shift of focus into tax dispute resolution and growing that space, and also in respect to public policy. Many a times previously, we used to wait for the finance bill or the finance act that brings the changes in tax laws to be published and then we comply. Now, with the change in constitution where there's opportunity for public participation, it has totally changed that. If I feel that the law is affecting me, what happens now is that I will lobby government, I will engage government to demonstrate the multiplier effect of some of the laws that they're bringing into place. So there's certainly an opportunity for lawyers within this space in developing public policy and at the same time resolving tax disputes that are emanating because of the space we are finding ourselves in. Decreased revenues, and at the same time, taxpayers are struggling with closure, increased restructures, reduced profitability. So because of that, tax disputes have so totally increased, and this is what we certainly will foresee a lot of these disputes in future.
Thank you, Christine. You raise the point of, the economic pressure with government being under extreme pressure to raise revenue, but similarly businesses as well being under pressure to deliver more for less. And just coming to even Mukiri as a practitioner, how do you see law firms having to adjust to the fact that companies are under a lot more pressure? They want more results, but they want to pay less. How does that impact on lawyers in practice, particularly on issues of billing and on service delivery, on efficiencies? How do you see that impacting on practitioners?
Okay, thank you, Kezi. I have been in practice now for the last 14 years, and of those 14 years, I have been a managing partner of a practice. And my experience has been that the legal sector is made up of two parts of the law. We have the legal profession, which basically is the advocates and the lawyers fraternity. And then we have got the legal industry. And both of them approach the law or legal services in a very different way. The lawyers are more inward looking, which basically means that we are happy to do things the way we have always done. I mean, we call it precedent. Whereas the industry is asking, how flexible are you in giving me what I'm looking for? And what I have seen is a disconnect between the two, where we as the legal service providers want to look into ourselves, whereas the legal profession or the legal industry is asking us to look outside. And I think my 14 years has been trying to bridge this gap. And for me, the trend will be, as the legal fraternity or as the legal profession, we have to start walking the journey of narrowing that gap by coming up with products that are relevant in the market and at the same time understanding the client who we are serving. So I think that is critical for me and critical for whoever is in practice or in the legal fraternity.
So, Mukiri, you now introduce the aspect of the fact that we are a very precedent-driven
Yes.
industry. We thrive on precedent, we thrive on what has been done before to determine what it is we are going to do today.
Yes.
So for you, Dr. Kwenjera, and I think also for Ongoya, skills development, is it that we need to reskill, retool for a changing world? Do we need to shift gears on the way we are training and preparing us to, face the constantly changing market dynamics? What do we do with the fact that we are, precedent driven versus the fact that we are practicing in a constantly shifting environment? Dr. Kwenjera first.
Okay, thank you, Kezia, and my co-panelists. Definitely, we are facing a lot of change. And for me, the changes are based in two sources. The first one is that, of course, we have a 2010 constitution that has introduced very many new facets of the law, starting with international law now becoming part and parcel of our Kenyan law automatically. Before it had to go through parliament, it is domesticated, but now through Article 2, we have literally brought in globalization directly. And you can argue in court through international law. I have seen some precedents on it. So even as we say we are precedent driven, it is not in the traditional way we were using it. Now you could actually be using precedents from even international law courts, which we couldn't do before directly. Anything based on a treaty that we have ratified is part of our law. So even as we teach law these days, we must have a bias or an emphasis on the fact that a lot of treaties that we have signed as a country are part and parcel of our law directly. We are now a monist state, no longer dualist as we used to be. Then the other thing probably that comes in is the 2010 constitution has been very innovative. We have introduced very many things. For example, Article 159 is a game changer. We are not going to get stuck to technicalities. And even as we practice law now, people will fight you on that point. Hey, don't tie me down to procedure. Let us go to the substance of the matter. It has also introduced the other aspect of dispute resolutions in alternative forms, whether it's traditional dispute resolution or it is mediation. It is now part and parcel of what we are supposed to do. So as we train future lawyers from the law school point of view, we have to take this into account. I know we tend to think the biggest change is in technology, but I think that the substance of the law itself has also undergone a lot of change, especially with the new constitution. And the technology for me will be a means of delivery more than as a substratum of what the law is. So maybe I can pass over to my colleague, Alicia.
I think just before Ongoya goes ahead, I want to put that question into context. We're talking about precedent not just being on the substance of the law, but in the practice of the law, in the thinking, in the wiring of the mindset of a lawyer. Wanting to fit within a structure that has been tried and tested, and therefore being unable to expand when circumstances require you to expand or to contract when required. So I'm talking about being precedent driven from a practice perspective, not on the technicalities on the law, but specifically on the business, how we carry on business. Are we dynamic enough to change when it is demanded of us? And is that ingrained and taught to us?
Okay, yeah, sorry.
Thank you, Kezi. Let me take it from there. Ongoya is my name, as we've been told, and on 15th of December this year, I'll actually have met the infrastructural qualifications to be a Supreme Court judge. infrastructural because they are cast in stone. Those ones are non-negotiable. You can't go before the interview panel and say, let's share some thoughts on these qualifications. No. So I've worked in the academy for the last 12 years. I call myself a reluctant academic because I have been in the academy hoping to exit anytime from quote unquote now, but tomorrow I find myself there. My experience in these two sectors has enabled me confront certain unique challenges. And I have monitored the trends from the time I was a university student myself to the time I'm a university lecturer. The environment has changed fundamentally. First, the legal academy has been liberalized. The people who, like Mukiri, are more than 14 years old in this practice only remember the names of 2 law schools. People like Kwenjera, who have been stuck in the academy, will tell you more than 20 law schools in the Republic of Kenya. And that's just how much the market has been liberalized. Liberalization of any market introduces its own unique challenges. Number 2, the character of the student has changed. The character of the student many years ago was the classical student whom you call and he comes running. Today's student is a customer. And you know how you treat customers in supermarkets. That's precisely how you treat customers in the academy. The character of the teacher has also changed. The teacher of yesteryear was a gray-bearded, pot-bellied, very fatigued character. Today, Dr. Kwenjera with us here is a dean of a law school. And let me not say Ongoya speaking, is a retired dean. Retired. He has served his term and retired. That's the character of the teacher today. So that's the environment that we are dealing with to deliver this service. The purpose of the academy has always been to generate a market-relevant graduate. To generate a graduate who is relevant to the market. The market is the most dynamic thing ever in the history of human interactions. The market changes so fundamentally, and I want to paint this picture so that you understand the nature of the challenge. The academy is a very conservative environment. Academics are very conservative people. Actually, if there are people more conservative than lawyers and priests, then it's academics. So now you are telling this very conservative person to generate a very dynamic graduate. Challenge number 1. There is a lag there, of course. There's some tension that you encounter when you have that kind of reality. But there are 2 approaches to this challenge. One is to ask, how do I inculcate new skills in the graduates? And that may look like the new way to go, but that's a very short-term view of things. Because new in relation to what epoch? No sooner has the graduate graduated than the so-called new skills become old and outdated. So that becomes a wrong approach to the academy. The approach by the academy today is, how do I generate an adaptable graduate? So that even as I inculcate the skills, I am cognizant of the fact that the skills are only new today, this morning. By this afternoon, they'll have become outmodeled. And yet the curriculum is behind me. The graduate must be dynamic enough to adapt to the new skills. That to me is the correct dissection of the problem. How do you engage your students? So as a law school, for example, one of the questions we have never been trained, and those of you who share generational relevance with me will remember, no one taught us entrepreneurship. We learned law as if law is practiced, I don't know as what. We went to the market and discovered that law is a service like hotel keeping. You must package it the way an airline operator packages his service to get a customer. So some of us are beginning to say that at the core of legal training in our respective institutions must be the question of entrepreneurship. So that lawyers come out equipped like any other entrepreneurs. Because in the realm of entrepreneurship, you are likely to be slightly more adaptable than in the realm of legal training. When I train you Winfield and Jolowich on tort, I mean, just how adaptable will you be by learning the law of negligence? You need a completely different skill superimposed on Donoghue versus Stevenson. For you, yes, to get the basic knowledge that you require for the practice of the law of negligence or tax law. But on the other hand, the soft skill that comes through learning entrepreneurship, so as to be able to confront this challenge of generating an adaptable lawyer. So, Kezi, as I come back to you, I think that is so. The second issue I just want to highlight before I hand over to you is the practice environment that you asked about earlier. You know, we were told that if the law is on your side and you are a litigation lawyer, you emphasize the law. You speak the law as if the evidence in that case does not matter. If the evidence is on your side, you keep the judges focused on the facts as if the law does not matter. And in the often set of circumstances where both the law and the facts are missing, you keep banging the table, saying nothing, banging the table, saying nothing, until the judge begins to say, maybe he has a point. Maybe I'm not the one who's getting his point, but he perhaps has a point. Today, where we are litigating online before our computers, you may actually smash your computer by applying the third skill of banging the table. And that environment has changed that significantly. It is critical, therefore, that even the skills lawyers employ in court, the tools of persuasion, have changed. How are we persuading people softly before? Through the flare of our language. We have no luxury of time for 2 hours of submissions with online litigation. Even if you want to take 2 hours submitting, your bundles will run out midway through your submissions. That is the reality of the environment we are dealing with at the moment. And therefore, our participants, I think, would work with us as not we share the skills on how to, but as we share thoughts together, us and them, on how do we get around and over these new challenges. Because in this, I can assure you, we are all learners. Back to you, Kezi.
Thank you, Ongoya, specifically for even raising the issues of emotional intelligence and soft skills. And I hope that we will come back to that. But I just want to build on what you talked about, building the entrepreneurial spirit amongst lawyers. Because, you know, for many of us in professional services, the professional services firms, we know that they're knowledge driven. You know, it is the deposit of knowledge in yourself and not necessarily the entrepreneurial drive or the business understanding. It has been predicted that the law firm of the future will not be a law firm as we know it, but instead it is going to be a highly evolved business unit, which will be delivering legal services together with, you know, a mix of knowledge specialists, innovation specialists, legal tech, marketing and business professionals. And I'm just wondering whether we have built in ourselves or what the landscape looks like. Is there an entrepreneurial spirit within the legal profession? And I'm throwing this out to you, Christine, having very recently jumped at a bandwagon. But in your experience, how do we see a budding entrepreneurial spirit in the traditional law firm? And specifically around being able to identify and develop products that are relevant. And I'm coming from the perspective that when a client walks into your office or into your chambers, the lawyers view the problem of the client as a legal challenge. But we must know that the client does not think of their problems as legal challenges. In many instances, they're business challenges. And therefore, the response ought to be a business response and not always a legal response. So your input, Christine.
Yeah, that's a very interesting question, Kezia. And I'll give you my perspective based on the fact that I was in a professional firm. I was actually at KPMG for 9 years. Then I transitioned into the corporate sector. So I was a recipient of the service, and then for another 9 years, and then I got out into consulting. And I think that movement has really helped me change my approach about professional services. As you rightfully said, when a client comes to you, he's coming up with a business problem. But it has always been that lawyers look at it from a professional perspective. I can give you a case based on my experience as a client. So we will have like a lawyer like Mukiri walk in. Mukiri will walk in many a times to come and solve the problem that I have told him. Rarely would Mukiri, I'm just using you for example purposes. Rarely would Mukiri come at the beginning of the year and ask me, Christine, how are you doing? How was business last year? How was the math like? Is it possible for me to see your financial statements? Is it possible for me to understand what your business plans look like for 2020? And without that interaction, I'll feel like Mukiri only comes to me when I have to tell him to do this and this. Whereas Mukiri has lost very many opportunities, because if he asked about my business, I'll be telling him, Mukiri, I'm actually launching a new product in the market. For Mukiri, he'll pick that up. There may be trademark issues there. I need to set up this plant in order to launch this product. Therefore, there's a big consignment coming in. Contracts need to be drafted. So me as a client, if he does not know my business, if he doesn't know my plans, he's losing out on so many opportunities, and he will not be top of mind as a service provider. I'll always view him as a lawyer, but I'm looking for partnership. I'm looking for a person who's really interested in my business. He'll help me resolve strategic decisions. You know, the legal framework becomes a strategic decision because he'll tell me, don't look at it that way. That will make the licenses very difficult to obtain. What about you do it this way? So he's using his legal knowledge to play within the space of strategy, within the space of tax, because you'll be telling me, why are you planning to do this investment? What about you do it here? You get capital allowances of 150% as opposed to the 100%. I will see value to the extent that when he brings his fee note, I'll be very comfortable to settle it. Whereas what has been happening is he'll do my work, send me a fee note. I haven't really appreciated the value, and we will now start haggling about fees. But he's walked with me the journey. He'll even bill me little fees, because for me now, because of the way business is, I may not have the professional allowance to pay us fees, but because he's been there throughout the year, he'll make his cut for the year. So the entrepreneurial spirit by lawyers needs to develop more so now, where we can't, I mean, we can't build those hefty bills taking into account the disruptions that are happening from a corporate perspective. So that's my view on that question, Casey.
Mukiri, would you talk about your experience in building an entrepreneurial spirit or an entrepreneurial environment within practice, and being able especially to identify even opportunities and not waiting for matters that are brought out to you?
Thank you, Casey. I think this is something that is very dear to me. And maybe I can start with when I left employment and my journey to starting the law firm. And I remember when I left, I was not sure whether I wanted to be a lawyer. I was not sure of the business I wanted to be in. And what I did for the first about 2 months is to sell printing paper. And I wanted to sell printing paper because deep down I felt I want to be a business person. And it took someone, I think on the second month, to tell me that, why can't you do that business within your law firm? Right? So I started a journey where I said, yes, I lean more towards the business rather than the practice side of the law, but I can do that within the law or within the practice. And so I have always walked and said, what Christine says, what is the service cycle? We call it the service cycle. When a client comes to you, you are just a small part of the cycle of the problem that he has or the need that he has. And until you wear the shoes of the client, then you cannot be able to serve that client well. So I think the traditional model of the law firm was where you would go with a pen and a paper, ready to just start saying, the statute says this, But the client wants much more than that. The client wants you to understand his environment, and the client wants you to walk his journey. And so it's been an interesting 14 years learning that. And the problem is that when you do it on the job, you make so many mistakes. You lose so many clients along the way, such that if the academia, if the regulator who are represented in this webinar are able then to develop specific skills amongst our lawyers, such that then you reduce the curve of learning those things. So are we sure, do we understand the client cycle? When a client comes to you and they are selling their land, do you know why they are selling the land? Maybe they want to raise money for medical expenses. Maybe they want to raise money for dowry. Do you get to learn why they are doing what they are doing? And when you get to learn that, then you are able to serve them more efficiently. And you are able to then walk and feel their pain. And by way of example, I know of a bank that was restructuring its loan products, and they hired a consultant. And what they did is the consultant sat down and said, if I am crafting loan products, can I then come up with a loan product that is based on the life of an individual? And so they developed products that when you get born, they will give the mother a loan for a newborn. When you go to school, they will come up with a student loan. When you get married, they will come up with a marriage loan. They will come up with a car loan. They will come up with a house loan. They even came up with a burial loan. So at the end of the day, they were able to understand that cycle. And so as lawyers, we must understand that cycle. If we do not, then we only offer our skill, but not our ability to just look at the issue in totality. So that has been my journey on the issue.
Thank you very much, Mukiri. And I think a challenge to us there to face the market and become responsive to what the needs of the market are. There's quite a bit of interaction on the chat section by attendees, and want to thank you very much. For anyone who has a question, you feel free to put it in the chat section, and I'm sure we'll be able to respond to it. There's a question to you, Ongoya, and I'll just throw it to you even as we take a pause and look at the questions here. Was it a good idea to liberalize the teaching of law? Was it a good idea to liberalize as much as we have seen that happening? And also somebody agreeing with you that we need to introduce, and I think to also emphasize the teaching of entrepreneurship for lawyers. Ongoya, do you want to quickly take that as we carry on? And maybe just before you do, Njeri Kamau, I see your hand is up. If you are interested in asking your question, you could either put it in the chat box or you could leave your hand up and we'll be able to allow you to, oh, that hand just went down. Irene Kashindi, the same, if you would like to make your comments, we will allow you to do that in a short while. Ongoya.
Thank you, Kezi. You know, our panelists must understand that when the liberalization of the legal academy began, I was a young, enthusiastic university student, very impressionable, easy to go to the streets and fight for what I regarded as a better space and my rights. And I was a great opponent of the liberalization of the market. Over time, I have come to understand what the great author of one of the Gospels wrote, that when I was a child, I thought like a child, but now I'm an adult. In fact, the question is never whether or not it was a good or a bad idea to liberalize the legal academy. The question is whether there was another option. It was inevitable. We live in a liberal world, and there's completely no way that you can stand in an idea, in the way of an idea whose time has come. So liberalization of the legal academy was not an option we had. It was the way. It was an idea whose time had come. It follows, therefore, that the option available to us was how to manage the liberalization, to manage it so that We don't compromise quality, we don't compromise standards, we still generate, proper, relevant graduates for the markets, etc., etc. The academy remained a bit more conservative. And I just want to to share an episode with our attendees. The traditional academy, how do you invigilate the exams? You lock people in a room, give them scripts, then begin hovering around them, walking around the exam room, hovering around them, claiming that you are invigilating the exam. Now, COVID has come and we are teaching online. You don't even know where the student is sitting as he's listening to you. You don't know. They're in their spaces. The way our attendees now are in their spaces. The exam we give our students today is no different from the poll you have just given our attendees today. How do you supervise, invigilate this? Can you do it the traditional way of locking them up somewhere, menacingly walking over their shoulders, seeing whether they are cheating or not? The environment is changing very fast. And as I've said earlier, liberalization was inevitable. What we require is just to adapt our approaches so that they manage the possible side effects of liberalization through a stringent, more proactive quality assurance approach to this. Mukiri has posed a challenge about the academy, asking these questions and seeing how it can bring to the market. But my own experience is this. It is impossible for the academy acting in isolation from industry to give us any competent graduates. There is need for synergy, for a great partnership between the academy and the industry. It is one thing for me to sit at Kabarak University Law School and purport to be generating the next generation tax law expert. It's quite another for me to partner with Christine Kahema and tell her, you know what, Christine, from your experience in tax administration, I want to partner with you so that the knowledgeable graduate I generate has relevance to your industry as a tax practitioner. And to me, that is the next frontier of bringing to the market very relevant graduates. The challenge we have is just a question of numbers, that the numbers are a bit too high, and we need to find out how we manage these large numbers so that the thin market can still afford us space and opportunity to give our graduates their experience so that they come to the market competent sufficiently. We shall again be continuing to partner with industry on even the ideas on how to manage these large numbers. I can tell you for a fact, you cannot reduce numbers. As long as men and women continue producing children, you cannot freeze some children of some people and say, you will remain aside for us to manage numbers. They must be admitted in their training institutions. And while in the training institutions, we must ask ourselves that you as Christian Kahema in the tax world, how do we ensure that we partner with you so that my 150 tax law students can nevertheless partner with you? Can you begin some online facility that can enable them tap into a portal of sorts and engage with you without disrupting your capacity to manage your clients or your core business? These are ideas which I suspect if we put our heads together, we will be able to manage the challenge of numbers without telling some people's children, let's freeze you out because we are managing numbers. That is not the way to go. We must accommodate everyone and perceive that as part of the challenges we must surmount and not a challenge to be avoided.
Thank you. Thank you, Ngoe. Let's talk about change that is customer driven. So we've talked about what a customer is looking for, that more and more clients are looking for business solutions and not just responses to legal challenges. And in the pursuit of meeting the customer demands or being able to be responsive to resolve the challenges that the customer may have, lawyers may find themselves wanting to integrate other services in the delivery of their legal services, thinking through, and that's why lawyers will probably get into the spaces of strategy. You probably even advise business advisory services around product design or product development. Kamende, do you see, or is the regulator prepared for a time or a season in time where you will have more cross-professional or cross-integrations across professions in the delivery of legal services? Are we prepared for a scenario where lawyers would partner with non-lawyers, for example, to deliver business solutions, you know, and legal solutions as well?
Thank you, Kezi. On that front, the regulator, that is now the Law Society of Kenya, currently does not allow any non-lawyer to gain profits from an advocate. That is what the rules provide. Neither do we allow corporations, unlike the practice in the world, where, for example, in the UK, you will find that lawyers can partner with non-lawyers, and there's regulation that is already in place. There are laws and statutes in place that regulate that practice, that incorporate non-lawyers. You find that in New Zealand, you will have corporate entities partnering with lawyers. In the UK, I think the law, the statute that governs the practice of law there allows accountants to be part of the structures of law firms. Having sat in the council for the last 4 years, I have seen applications under Rule 10 of the rules that govern practice of lawyers under CAP 16 attempt to apply for the council to approve partnerships with entities so that they can offer legal practice, opinions, and advisories. And that has been declined because we do not have a law that allows other than natural persons and also lawyers to practice in their names. You will also realize that there has been a problem in approval of generic names. And the Council of the Law Society under Section 81 of CAP 16 is allowed to formulate regulations and laws and rules that will govern the practice in Kenya. Part of the mandate of the Law Society of Kenya is to assist members in the welfare and practice issues. We are in a world where everything is changing very fast. So it's inevitable that the Law Society of Kenya has to look that way, because the future of the law firm now is changing. Central to this will be legal tech, and central to this will be marketing and partnerships. What we witnessed during the COVID-19 was a collapse of many practices. We woke up one day, I had a diary in my house and a file, a hard copy file, and I had a matter in court, but I could not attend court because we woke up one day and the world was shut, if I may put it that way. So it is now inevitable that the regulator of the practice in Kenya, that is the Law Society, must look this way in order to improve the practice of the advocates that they regulate. Kezi, the resistance on advertisement was because of the aspect of looking at the law as a commercial aspect. We may not run away from that. The truth of the matter is clients now and customers are looking for business-related solutions from lawyers. So we have no other way other than changing the legal framework so that we can incorporate the demands of our clients and allow lawyers earn fees, because the world is changing at a very fast pace. So, and lawyers will now have to focus on their skills on providing intelligent business solutions for their clients, assisted by technology, so that we add real and reasonable value and measurable value to the solutions that we offer. As the regulator then we will have no option to meet the demands of our members that we regulate. Yes, the legal framework does not provide. The LLP Act number 42 of 2011 provides for two or more persons who may be natural persons and corporate entities making up the LLPs. The Law Society is yet to embrace that. So we need now the Law Society to focus on formulating policies and regulations that can embrace the provisions of that act, such that we may also have to allow entities to partner with our members. And of course, it has to be regulated. Like in Singapore, they do not allow incorporation of non-lawyers to practice any other thing other than law, such that if you get a tax expert, let's say like Chris Nkahema, into my law firm, Kamende DC and Company Advocates, whatever input that I will get from her must be in enhancement of my practice of as a lawyer and of law. So we have to embrace change, and we have to now start thinking outside the box. The box being that the law firm that is just a sole proprietor, an LLP for partners who are natural persons, and partnerships carrying on legal work. But we have to think, I know that the fear is infiltration of the practice by non-lawyers, and of course rendering our own members jobless or businessless, if I may put it that way. But with proper structures, we may have to open up the legal practice so that we meet our clients who are members now as regulator needs. So there is need to change the legal framework.
Mm-hmm. I think, Kamende, the other side of that question would be rethinking the actual definition of what legal practice is. Ongoya alluded to the fact that we now have numbers that exceed the market opportunities. So you have a number of graduates leaving the university, and you can no longer draw the trajectory, getting at associate level and work your back off until you get to partner level. It is no longer as it was. So we have numbers exiting universities and not necessarily being absorbed into the traditional thinking or definition of what legal practice is. And what we are likely to see is the mushrooming of offshoots, legal innovators. And I think, in fact, with the rising of legal tech, we're likely to see a lot more professions, so to speak, or branches of legal practitioners in hitherto unknown professions. And I wonder how the regulator will be thinking around regulating those mushrooms or those mushrooming subsectors or sub-professions of the legal practice.
Thank you, Kezia. And there, like I had said earlier, there has been some growth in the way we practice law, right? From when the regulator could not allow a person who is freshly from the university to open a law firm, up to 2011, I think, when that was allowed. So that was one step in allowing the mushrooming numbers. Currently, I think we churn around 1,400 new advocates per year. I recently attended, in February, I think 827 advocates were admitted to the bar. And that's not a small number. And like you say, traditionally, we all used to look for law firms where we can hang on. Now, the law firms are few. Now, we cannot accommodate this. So it is inevitable that the regulator may have to open up practice areas. We have to incorporate new areas of practice. We have to allow advocates to be innovative. That is by changing the the legal framework to what I had said earlier, that we can regulate advocates venturing into other areas other than the normal practice of the law. So we have slowly also moved from the sole proprietorships regulations to partnership regulations to LLPs. And what I had indicated earlier was that I have seen many applicants come into the society to be allowed, applying for approval to be allowed to incorporate or bring on board corporate entities. So in order to accommodate our mushrooming numbers, I think the regulator needs to formulate policies, as I said earlier, to accommodate this. We need to expand what we call the areas of practice, what we call what qualifies to be an approved or an area that we must approve for lawyers to practice, because we are many, we cannot accommodate each other. So lawyers are becoming innovative, that is true, and the trend would be that the modern law firms will now start operating like businesses. And as the regulator, we need to start looking at how we can encourage smart online marketing and the strategies that may enable our members to practice law or other beneficial skills that may bring food on the table. So I think change of the legal framework is inevitable. That is what I'll say in Assam.
Okay, thank you. Thank you for that. Dr. Konjera, I'd like for you to probably input on this. But in addition, Dr. Konjera, thinking around globalization, and we've seen basically all industries getting to a place where we have collaborations across the globe and across the region. And very specifically, I think even for the continent, I'm very passionate about internationalization of trade, and specifically trade within the continent. And wondering, within the CFTA, Continental Free Trade Area Agreement, and the Protocol for Services in there, how lawyers in this market are leveraging on that, or positioning themselves to leverage on opportunities in the region, either through building Pan-African outfits, or building partnerships and collaborations. How do we build the thinking of collaboration as opposed to competition within the industry?
Thank you, Kezia. Before going on to this issue of collaboration and a Pan-Africa outlook, I wanted to throw a spanner in the works of what Caroline Kamende was saying. And it is that increasingly we are having more lawyers possessing a double qualification. On this panel before us, half of us wear two hats. I think Mukiri, Kahema, and myself are fully qualified accountants. We have a qualification as accountants. We are CPAs. I think some of us actually belong to LSK, but also we belong to ECPAC, and there are many other lawyers who also belong to ICPSK. I think they have changed their name now, Certified Public Secretaries. And this is a challenge because LSK will have to think, how do we work with the other professional bodies, given that some of our members have already embraced a business qualification? Sometimes I feel the conflict, and people ask me, so are you a lawyer or an accountant or an advocate? Where do you go? I would like to do both. And I think it is very possible within a law firm or within a firm of accountants for me to actually practice either of the two, or I should be able to leverage on both to give better advice and better services to my client. So when we go into consulting, for example, I don't have to be an advocate to do consulting. There are certain things which I must have an advocate's qualifications to do, but there are many other things in the business world which I could do without wearing my advocate's hat, although I have it. That was just a comment I wanted to make more than provide a solution. It's something we should think about. How do we make sure that, let me use an agricultural term, we can have a crossbreeding between the professions so that we have a better output or crop of professionals. Even right now, there are many young law students who come and ask, could I also be doing CPA, ACCA, some business course? And I know there are even who are doing marketing courses who are law students. So when they finish, they will have this double qualification. And some of them have even done internships, not in law firms, in business enterprises. So when they graduate, they are well prepared to be in either of these spaces. But more than challenge a person to try and sort of moonlight in a law firm or moonlight in an accounting firm or in a business, I think we have to realize that the modern lawyer, the law graduate we are going to get, is versatile, has more qualifications, and you don't have to be modern. If, as I said, I am not modern, maybe now I'm old, but I have the two qualifications. So I shouldn't have to think, oh, now let me open a kiosk somewhere as an accountant, but then I also work in a law firm somewhere. I think we have to be able to create the synergy and how we can have this harnessed, these two or three qualifications harnessed to produce a good output for our clients. About having a Pan-African outfit, I think there are challenges there, given that, for example, even the EAC, even before we go too far, the EAC itself is not working too well. How do we ensure that I can practice across borders? Is one of the issues that are arising. We have Ugandan students in this country who had to go to court to be allowed to do bar school in Kenya. And we have had quite a number of court cases whereby students from the East African countries, not Kenyans, have had to fight their way into Kenya School of Law so that they can qualify as advocates in Kenya. And once they qualify here, then when they go to Uganda, the question is, if they never went, say, to the Law Development, it's called LDC, Law Development Center in Uganda, will they be accepted easily to practice law in Uganda? And these are challenges that have to deal with the professional bodies of lawyers in these countries. And before we get to the countries working out the EAC treaty to make sure that movement of goods and services and people is made easier, I think that the law societies of these countries also have to open up. And without that, it will be impossible for us to take advantage of the globalization that is happening. There are very many opportunities, but there are regulatory challenges, and some of them rest at the level of the professional organization rather than at the Ministry of Foreign Affairs or government working with each other to make sure that the EAC treaty, for example, works out. That's what I would have to say, Kezi. Thank you.
Mukiri, any comments to make on partnership development across the region, across the globe, enhancing capabilities of the practice and collaboration?
Thank you, Kezi. And the market we are in is a market that is globalized. Traditionally, the client was a domestic client who had an office in one country. And currently what we have is that client expanding and probably having offices in 2 or 3 countries across the globe. And the traditional lawyer model was that you only had the capacity to serve these clients at the domestic level. Now, to serve your client at the global level, you need partnerships with other law firms, you need partnerships with other companies and with other entities. And so I know as lawyers, we may not be very good at collaboration because our background is that we are told that it is a winner takes all mentality, right? which means that each person is a competitor to me. But I think collaboration would be advantageous at this time. Currently, we have foreign law firms that have come into our market and are doing business with law firms here domestically. And maybe the question for us and the question for the regulator is whether our law firms are being able to do that same thing outside there. So do we have reciprocation arrangements with such countries? Are we getting the same benefits that these other foreign law firms are getting by coming into our space? Are we regulating those foreign partnerships that are coming in? Or can we even come up with a vehicle that allows that type of joint venture? So there are many questions, but I think collaboration is the way to go. Remember, the traditional model of the law firm was one where you are a general lawyer, which basically means that you can do everything. So you can go to court, you can do conveyancing, you can do mergers and acquisition. So you have a bit of everything, right? But the future is for those who are highly specialized. So if you are very highly specialized in your practice, then there is no way that you can offer all the solutions to your client. You have to collaborate with someone. You have to say, I don't have this skill. I would want to engage the mergers and acquisition person. And so maybe for us as future lawyers or as owners of future law firms is to map out how will that collaboration work so that then the client gets the value that they are seeking. So collaboration is there, and not just at that level. Even domestically, we have law firms that are bigger than others, and we can have collaboration. I know that there are some of the law firms where they may have a threshold of the type of work that they can handle. And the question is, when the client goes and asks for that type of service and is told, no, we can't handle that, is there a system where that law firm can actually say, oh, we do have a panel of advocates that you could consider to handle that? So do we have collaboration that is refined, or is it that the client will be told no with no advice on what to do? So we can map out collaboration. I remember when I was starting off, I was very lonely because I didn't know what to do. I made a lot of mistakes. But I also know that there is another advocate sitting elsewhere who had 20 years of his mistakes or her mistakes that he or she could share with me. But there was no space where we could collaborate. So we need to ask ourselves, how can we collaborate better as law firms, here internally, domestically, but more importantly, through our regulator, how we can collaborate with other law firms in other jurisdictions. So we can upscale that, we can give it a form that is more organized than it is now, because the future is globalization, the future is specialization. So how do you connect that? That one requires you to be specialized and the other one requires you to be everywhere. The answer is collaboration. So if we refine that, we get it right, our markets open up and we make more money, which ultimately is the dream of any business person. Thank you, Kezi.
Yeah, yes, indeed. And across different industries and different sectors, collaboration is a new buzzword. Kamena, maybe you can tell us, is there even conversation perhaps within the law societies, even just in East Africa, but even in your role as a chairperson of the Kenya chapter for the Africa Bar Association, maybe beginning to think the associations or the law societies across the region, beginning to think that we perhaps need to have. And I ask this question knowing very well, for a long time, the world has referred to Africa as the last frontier. It's not the last frontier anymore. It's a frontier right here and now. And we have, I mean, even law firms in more developed markets beginning to angle and position themselves for African business. So just wondering, what would the law societies in the region be thinking around building the muscle of African law firms through partnership?
Thank you, Kezi. Sometimes back when I think President Mamu was the East African Law Society president, there were discussions around cross-border practice. And I remember there was a lot of negotiations between the law societies and the different bar associations of the ELS. And I think some members were acceptable, some other members were not acceptable. And that was the end of the discussion then. It has never been picked up. I think it's high time that that cross-border practice is put to table again. There is a problem for a lawyer to practice to be admitted to the bar in Kenya. We only allow a few. The regulator only allows a few of the citizens of other countries to be admitted in Kenya. We currently do not admit those from South Sudan, I think, and Burundi. So I think to be able to allow non-Kenyans to practice here, or for us to be allowed to practice outside the country, then there is need to incorporate foreign law practice in our regulatory framework. Like if you look at Singapore, they have incorporated the foreign law practice in the act that regulates them. That is the Legal Professions Act. Currently, we do not have such framework in the country, and you will note that international practice needs and requires reciprocation by the other countries. So it will be difficult to allow an advocate to come from Sudan to come and practice law in Kenya, yet we as the Kenyans cannot practice in their country. So it's high time that these MOUs and practice discussions are put on the table by the different bar associations. I am the chairperson of the African Bar Association, the Kenyan chapter. What does the bar do? It's just to foster good relationships with the bar associations and individual members from the countries. There is no talk on business per se, because our different jurisdictions do not allow that. So other than an association like IBA, allowing Kenyans to go for a conference and build personal network, we do not have space or any framework on opening up space to discuss business. So I think this is something that we ought to take up, as the regulator, but of course you note that it depends on reciprocation. If there's no reciprocation, then we will not open up our space for other people when they don't open up space for us. But it's something that can be pursued through MOUs and discussions by the different stakeholders and the bar association.
There's a number of questions just emerging from lawyers who I would imagine are at the formation stage of law firms. And thinking that the tradition has been that you just jump ship and you go to the deep end and you begin the process of tying strings together in the process of formation of a law firm or starting out a practice. Just wondering, Dr. Kwenjera, and I think also with Ongoya, I know we have talked about the need to build entrepreneurial skills, but perhaps thinking through models that allow forms of mentorship, and I do know that there is a bit of that that's going on, but more structured forms of mentorship. But besides mentorship, thinking about structures of law firms that would allow more established law firms maybe to partner with startup law firms, you know, and build those inter-firm collaborations as well. But maybe Kwenjera, your thoughts on that from the skilling process?
One of the things I have seen a lawyer doing, a senior lawyer, is supporting an associate who left the main law firm to go and do their own startup. And I saw that this person would mentor this young person who has started their own law firm on how to go about it. I haven't seen many lawyers, older generation, doing this, but I've seen one particular one do it, and it works very well. And in fact, what he does from time to time is when he has extra work is to call that person and say, hey, look, there's this client who came. If you want, you could take up this brief, or could we work on this brief together? Or maybe the lawyer, the younger one, has started a law firm in another town, say Nyeri, Mombasa, and then this lawyer in Nairobi gets a matter that needs to be dealt with up country in a registry or in a court. And instead of saying, look, I am going to travel to Mombasa or to Nyeri, no, there is this associate who worked in my law firm for 5-6 years, and he could handle the matter for me. And the client will pay me or will pay that person. And there is a way we will work out the fees. But besides sharing work, it's also this person mentoring this person on how to go about building their own brand, building their own law firm. The other thing that we are doing, which is futuristic, and it is not yet working out very well here at Strathmore, is we are going to what we are calling industry mentorship. It's not just the mentorship of helping a person pass their exam and get their degree. What we are trying to do now is to work with law firms, and we are senior lawyers to basically adopt, not an individual student, a group of students to mentor them on the business of law, even as they go through law school. So Mukiri may have 3 or 4 students from our law school going to him for just a chit chat on what happens in the law world. So by the time this person is finishing their law degree, probably they have met a senior lawyer who is running a practice a number of times just to learn from them. And I'm not talking of internship. I'm talking of just a breakfast or something that they do. They meet in your law firm or in some restaurant, and you tell them what is happening and how the future looks like. Because sometimes the young guys are very idealistic and they may not have the feel of what happens on the ground. So when we arrange for them to work with a senior lawyer as an industry mentor, then they get to learn, how do you run a law firm? What are the challenges? What are the opportunities? So they come out as better prepared graduates at the end of the day. So maybe that's a way of sowing the seeds of the older lawyers, mentoring the young ones. So even when they start the law firms, they are not starting from scratch. As they went through school, they learned from an industry mentor how this is done. Yeah, those would be my comments, Kezi, unless I left out something.
Angoya, do you want to add anything to that?
Yes, I have 2 thoughts to add to that. First, I share what Dr. Kwenjera has said, almost hook, line, and sinker. But again, we need to reflect on this question of mentorship, Kezi. Young people listening to us must understand that mentorship is a very strange phenomenon. Now, I will not walk from my chamber, Kezi, to come to Mukiri Global and tell you, Kezi, I now want to mentor you. Now I'll be reporting to my chamber every Monday at 8 o'clock in the morning for mentorship. That is not how mentorship works. Mentorship is actually more mentee-driven than mentor-driven. It's a case where I've seen how Kezia does her thing out there, and I say, I want to be like Kezia. I therefore begin walking through your shadow, sometimes even without your knowledge. Just to understand, where do you place your foot, so that I place my foot there in the hope that where you will end up, I will end up there. That's how I perceive mentorship. And that's why I categorize mentorships as 2, direct and indirect. Indirect, for example, you say, you want to be like Maya Angelou. She's dead. You read her work, you encounter stories about her, and you try to fashion your life around her the documented aspects of her life. I want to be like Mandela. He's dead. But you listen to stories about him, you watch documentaries about him, and you want to fashion life like him. It's not Mandela who is driving your life, the mentorship. It's actually you walking through the shadow of his life. But in terms of what we are talking about here, where senior existing lawyers guide young lawyers, my own experience is this. One, even though we are talking about law firms of the future, there are certain traditional values that were there, are there, and will remain there to the end of time. Values of honesty, values of hard work, values of excellence. You know, these things are not replaceable. Whether you become technologically minded, whether you become old school, whether you become old fashioned, these things are of enduring value. One of the things on which I receive complaints about as an academic, as a teacher from the industry, is just that you are not giving us people who are a spirit of excellence. You're not giving us people who are honest. And I keep telling you that, you know, some things must have been taught by these people's mothers and fathers at home. That to expect the academy to teach some of those things is to expect sometimes too much from the academy. That's not to shirk responsibility, but just to underscore the point that our listeners, particularly those of them who are asking about mentorship, must understand that there are certain core values that they must wear throughout their existence. They must put on. Those things must be second nature to them. As a mentor, you are more inclined to guide a young practitioner, a young student who is predisposed to hard work, predisposed to respect, predisposed to discipline, than an indisciplined, non-hardworking, you know, just somebody who is just there, so to speak. It's very hard to mentor such a person. So it's critical that they take this in their mind. At Kabarak Law School, what we are struggling with at the moment is training a lawyer with a mentality beyond legal practice. I mean, that's one of the greatest things we need to undo. The assumption that you have come to Strathmore Law School, that Dr. Kwenjera is in, to go to a law firm and become. It is true that is one of the options available. And you must train knowing that that is not the only option available. No, it is one of the options available. And therefore, I mean, when I meet young lawyers who have become DJs, applying their knowledge of intellectual property as DJs, I feel excited. I want many of them to become butchers and other things, who understand better contract law in butcheries and so forth. The point I'm emphasizing is that we need to expose budding lawyers to an understanding of entrepreneurship beyond opening a kiosk called a law firm. Once we get there, we'll be good to go. It will be possible for lawyers to, you know, venture in fields that are not necessarily regulated by the law society of Kenya, because they're not practicing law. But remember, knowledge is in them. Once you've trained law, the law society of Kenya will not tell you, before you run a butchery, and do your legal training first. No, you will deploy whatever spirit that the legal training, whatever discipline the legal training can train you into new industry. And just new areas. I mean, the area of sports, the area of entertainment, what are lawyers doing there? These are multi-billion shilling enterprises that if how many lawyers trained in Kenya will find the core of their practice in Hollywood and Bollywood, we know that the amount of dollars in circulation is multi-billion. And they will be partaking a part of those dollars by virtue of orienting themselves there and rendering their skills and their services there as it was. So this is an aspect that I think our listeners need to internalize. What I would emphasize, nevertheless, that people don't forget, is that let us not wish away the place of traditional values. These things are enduring. These things are non-replaceable. The world may change. The law firm may become a law firm of the 23rd century, but there is no client will consult a conglomerate of, you know, joint ventures of lawyers who are known to be dishonest, who are known to be lazy at work, who are known to lack a spirit of excellence. So these values are critical, and young budding lawyers must work with them. I know of a young person, case, just a personal experience, who walked into my chamber and he had just opened his law firm. So you can imagine he had no single client and he was a bit idle. But he told me he wants to spend the next 2 weeks in my chamber, reporting there, not as a man employee, to sit with me in my room, to go with me for tea, to go with me for lunch. That was his understanding of mentorship, to pick up some mannerisms. Well, he may have picked very many very bad ones, because I have quite a number of those as well. But I can imagine that that spirit of a self-driven mentee is quite beneficial. When he gave his closing report, I was quite proud to be associated with building the commencement steps of his career. As we speak today, I talk to him virtually every week, and I think he's not struggling. He's not rich and famous, yes, just like myself, but he is not dying of hunger. So I think that is something that young lawyers must also pick as they go along. Then finally, before I forget this point, Mukiri mentioned something. Making money is the ultimate aim of every business person. I mean, if you went into business with no intention of making money, then there are many other sectors that can accommodate you, not the business sector. But again, more important for young budding lawyers to understand that if you invest in success first, money will follow you. But if you invest in money first, both money and success will run away from you. And that's critical that they keep at the back of their minds.
Thank you, Ongoya. I summarize what you have said in the initials VIP. You focus on developing value, you will generate impact, and thereafter profit will follow. Profit has a habit of following value and impact. Thank you for that. Let's talk about some of the unintended consequences of the development around technology, legal tech specifically. The challenges of data protection, the challenges of ensuring that we are able to maintain the lawyer-client confidentiality. I know that we will be focusing, having a dedicated webinar on law and law innovation and technology later on in the coming weeks. But just probably a focus on the challenges around tech, even for lawyers. We now have litigation happening virtually. We have the courtrooms of the future already happening in the present, and a lot of meetings happening virtually. What is the exposure? What is the risk? How are we mitigating that risk? And how prepared was the legal services industry or how prepared were we for the virtual environment and the risks and challenges that come with it? Kristen, you want to go first?
Okay, interesting, Kezia. And just before I address that comment, I just wanted to pick up on something that Ongoya and Dr. Kwanjera mentioned in respect to the kind of students we have and the opportunities that are available. So as you say, the opportunities are very limited. And I like the fact that academia is actually looking at churning out students that don't really have to focus in rendering their services from a legal perspective. They're expanding this. And I can assure you, I've seen this because when I look at the tax class I attended when I was in the University of Nairobi, and the expectations of Peter Kwanjera of me when he tells me come and teach this class, they're so totally different. So I must commend the two gentlemen in the academia field for trying their best to just give us the best, caliber of lawyers in the market. And maybe just to mention in respect to that as well, is to see what that has done in the Big Four audit firms. I know I'm conflicted when I speak about the Big Four audit firms, Kezi, having in mind that I'm an ISPAC member, but we are seeing an increase in hiring of lawyers even in that field. I can tell you, and it's because the thing that we pride ourselves as lawyers is that every single transaction has a legal implication. So you need someone who has the legal mind to interpret statute, to play a role in mergers and acquisitions, in tax, even in normal audit. So there's definitely a lot of services that lawyers can actually offer, and it's just by expanding ourselves that we'll be able to target those kinds of services. The issue of the changing technological space definitely affects us in our field. I gave an example, for example, from an IT perspective, the Revenue Authority has become extremely digital, and that has resulted into increased compliance measures, and also having in mind that confidentiality issues may arise from that field, trying to see how is it that you protect a client, because a lot of confidential information is in there. And I can give you an example, Casey. If I have a transaction with you and you tell me, give me your PIN number and give me your password so that I can access your details, your KRA details, I'll certainly be very sensitive in respect to that issue, because there's a lot of confidential issues from that perspective. So I'm expecting that the law firm, even though I haven't signed a confidentiality agreement, because maybe not all transactions are contract-based, that you will uphold the confidential issues. So with the virtual space, with the growth in the digital marketplace, and that's one other thing that we are seeing, Casey, from a global perspective. The world is becoming smaller. We are communicating more from a virtual world. Transactions are happening more, not from a brick and mortar perspective, but on the digital platform. Many other legal issues are emanating from that, both from a tax perspective, from an intellectual property perspective, and client confidentiality is key now, even more important now than it was before, because of how easily you can access the client information and how easily that information can be accessed in the event of breach. So we lawyers are deemed not to be very IT savvy. I know we are getting over that space, but it is here with us. We've got to see how best to be ready for the market. And from an academia perspective, other than doing law and science, I think we really need to bring out this issue of technology, not necessarily as to how to render services in that field, but as to how to package our services to fit into the current state we are in. Thanks, Casey.
Mukiri, the challenges of threats, as lawyers, being able to mitigate those challenges, and at the same time balance the risks with providing seamless, efficient services to clients. How will lawyers, balance the need to provide, excellent customer-centric service, efficient, have efficient processes in their workplace, but at the same time mitigate the threats, specifically cybersecurity threats? Any thoughts on that?
Okay, thank you, Kezi. I think if we are to be successful lawyers of the future, we cannot run away from technology. And I do hope that the young lawyers who are listening are able to make sure that their businesses are technologically aligned. I remember my first discussion with whether to become technologically aligned was at around 2012. And at that time, the discussion was, do we really need a client management system for the law firm or not? And I do know that there are lawyers who are still not in the space where they have a technology driving their businesses and have the traditional model where it's still the files, the big files and the big filing cabinets. And the challenge with that is then you are not able to serve your clients efficiently. Remember that the client today is a very discerning client. He has access to information on the internet, and by the time that he's coming to you, he already knows what the law says, and probably all he wants is your professional judgment of how to go about it. So if your client is relying on technology, then you as a provider of the service cannot run away from that technology. And Kamende talked about alternative business structures that have come up. My research tells me that for every one client who seeks services from the lawyer, another 4 are lost. 2 are lost to such alternative business structures, and another 2 choose not to come to the lawyer because of prohibitive costs or because they do not understand the environment with which we operate or offer our services. So that means that we are losing about 80% of clients who would ordinarily would come to us for services. And the reason why the alternative business structures are being able to eat into our market is because they are relying on technology to come up with flexible services and services that are quick. I was looking on the internet the other day, and I saw a flash, someone telling me, if you want an affidavit, you can download, here is the affidavit. I saw another person, I think there's a company called Chatbot, another one called Rocket, another one that is called Legal Zoom, and all these are in the space that lawyers should occupy. So how do we then compete with them if we are not technologically correct? So the beginning point is we cannot run away from technology because technology is the future. So if we are going to serve our clients efficiently, we must be technologically correct. Coming to the issue of data security. Remember, data is king. For you to make decisions today, you need to rely on your data. How many clients are asking me to offer this service? How many clients have I served this past 1 week? So without collecting their information, you can't make any decisions, right? So we are caught in between the rock and a hard place. We need to collect this data on clients. We can only store this data in the cloud. There's really nowhere else. You can put many servers, you can put a lot of vaults that makes it impossible to access that information. But the fact remains that hackers, when they want that information, will actually get that information, right? So, and I was reading somewhere, I think 2 months ago, where a law firm that has served musicians in the US had its database hacked by hackers. And the hackers were now selling information about those clients, including Trump, to the highest bidder. So these are things that will be part of us. And whereas we can limit by doing the best that we can from the point of view of putting the controls that we should put, it is a risk that we have to live with. So I think our role is to ensure that we are not negligent. We are not negligent in the handling of that data, and a client will not come and say, you released my data unauthorized. When the hackers come knocking, then I am sure that with time, we will be able to limit those instances, but I doubt whether we can eliminate those instances. And those who are IT specialists can tell us, and lawyers can share their experiences with respect to the issue of hacking. Today, you have got the mobile phone on your hand, and you have input a lot of your data in that mobile phone. Someone can access that mobile phone whether you want it or not. And we have many cases in court where hackers have been able to do that. And I doubt whether it will be any different for legal services, but we cannot shy away from technology. And any lawyer who is running a law firm and has not invested in some form of technology is then really limiting their ability to scale up their services. And I would advise that let's look for those because they are out there. At the basic level, get the system which allows you to manage your client, and at a higher level, come up with legal products that are modern and that will drive the market going forward. So that balance has to be there, and we have to live with the threat. Those are my thoughts, Casey.
Thank you, thank you. Lots of questions in the Q&A section and in the chat section as well. And at the same time, I'm looking at the clock and time is racing fast behind us. But even for our panelists, to encourage you to get into the Q&A section and see if we can respond. And if there are questions that we'll not be able to respond to, I can guarantee you that we will find a way to be able to address those questions, maybe directly to the person's asking. But Christine, the hot potato, the big four, the big four, and you did allude to the big four. As at November 2018, PwC had employed about 3,600 lawyers in 98 countries. EY had about 2,200 in 81 countries. And I know this is a question. And if you do the tally amongst the big four, you will have nearly 10,000 lawyers in across several jurisdictions employed by the big four. Is it, and I know this question has been asked in many forms and in many shapes, and there are many sentiments around it, but is it an opportunity for collaboration or is it a threat? is it competition or is it collaboration? How ought we handle the big four and the others that are coming along? And I know this is putting you on the spot, but yeah, let's hear it from you.
Yeah, you're actually putting me on the spot on this one, Kezia, because I sit in the tax team at the Institute of Certified of Public Accountants. I sit in the tax committee. It's predominantly accountants, but we have lawyers. Actually, the other lawyer is Jemima from our class as well. And then I sit in the tax committee of the Law Society of Kenya. There we have 100% lawyers, but you have individuals like Ngumi, who's also an accountant. And you realize that tax is extremely dynamic, and tax has been predominantly done by audit firms, mainly accountants, but as tax continues to evolve, you realize that it's an issue of law as opposed to accounting. So the reason as to why audit firms have increased the number of lawyers in their teams, they've realized that because the issues that we're finding ourselves into are legal related, you really need the legal minds within that space. You know, so they definitely have their audit clients, but tax consulting has become so big to the extent that even what's happening in the more developed worlds, they're trying to separate those two. So in essence, they're saying that this is a service that is so rich in itself, it doesn't find itself as part of audit. You know, and you can imagine from an auditor perspective, an auditor is supposed to be very independent, offer professional service to the extent that they've reviewed the books of accounts and they feel that the books of accounts are right, and they give you an auditor's certificate. On the other side, the consulting work, the tax work is more of a value addition, because you're telling a client, look here, there are so many opportunities to optimize from a tax perspective. I can do for you this due diligence in respect to your mergers and amalgamations that is being done by the transactional team in the audit firms that really need tax or legal knowledge. I can do for you the review of the contract. So I think the reason as to why the audit firms have really thrived in this field is because of the restrictions the legal firms have. Though Kamende, you're saying there's quite some development from that angle, and we're actually feeling it. I can see the number of tax law firms coming up are more now than they were before. So is it a threat or is it an opportunity? I wouldn't want to call it a threat, because I can tell you after this, if you share this webinar, I might just be stoned. I think it's more of an opportunity to collaborate more. I mean, look at that audit firm. Does it really have to hire the lawyers and restrict the lawyers? Because when you're a lawyer and you're hired by that audit firm, there are some things you can't do. You can't represent a client at the High Court. You can actually present a client at the tribunal. But what about we collaborate more with the law firm? So I run my practice as a lawyer. You've got services that really need the legal practice, and I won't get restricted, and you'll have the best of your world. And we can do tax dispute resolution as a team, because if it's a tax matter, I need a tax advisor and I need a lawyer as well. So it gives us an opportunity for collaboration, and you as a lawyer who's been trained as a lawyer, it feels bad when you have to work at a place whereby you're very restricted in the kind of services that you can render, even within the legal practice. So it's certainly an opportunity for collaboration, thrive with, give more solutions to clients, and that's what the client is looking for. He's looking for a business solution. He's looking for that person who's going to mind his P&L, who's going to say, I realize you've got this amount of expenses, I can reduce them for you. If you just give me a small amount of money to do that for you, small in terms of, I mean, yeah, but I mean, you as a service provider, you're actually getting the fees that you need. And with that mindset, we can actually make businesses thrive even more. Yeah. And also, I mean, and you know, with a thriving business, everyone is happy. The government is happy. You as taxpayers are happy. The people learning. I mean, there's a lot of personal fulfillment while rendering those services. So I don't look at it as a threat. I look at it as an opportunity. And I can assure you, even as I sit in both committees, we are trying to see more and more how we can collaborate better and leverage on each other's strengths in order to make the tax practice more coherent and stronger.
Thank you, Christine. For our attendees, just to encourage you, if you did not participate in the earlier poll, just do let us know what category best represents you in just about 30 seconds. What category best describes you? Here, yes, I think we have a lot more practicing lawyers in the audience. So we will end the poll in 20 seconds. See, time is really chasing after us. If you could just participate in the poll and do let us know what category best describes you. Okay, I guess we will end it at that point, and you can participate in one of the other polls that will be coming up in a short while. Well, so I think let's move on to the millennial question. And I know we don't have much time, but I just want to ask the millennial dynamic, the buying patterns of the millennial, the fact that we have more millennials getting into decision-making positions, even within corporates earlier on in their lives. And therefore it's affecting the buying patterns. Within the law firms, you have more millennials and affecting the structure of the law firm, or I think the flow, the decision-making processes within the law firm. Is that a factor? Now, I would just shoot that to you, Mukiri. We could just respond in 30 seconds on that one.
Thank you, Kezi. I think for me, and from my experience, that is a major factor, both with respect to how the clients want to be served. Currently, what we have is that most of the clients are millennials, which means that they already know what they want. And again, all they need from you is a certain type of guidance. They want the stamp that they can't put on their document, the license that they can't have to go to court is what they are looking for from you. But this client already knows what they want. And so our services, and maybe any other law firm services, have to factor the fact that this millennial is different from older generations. They want their work now. So I remember we used to make a joke where a law firm would get instructions on Monday and then write back an email, a letter on Wednesday to say we received your instructions and are perusing the enclosures. And then they ask, on Friday, they ask another letter asking for documents that were not enclosed. And so a whole 1 week would get lost in the correspondence. Today, clients want an answer now. So you will have a client asking for a service in the morning and they want the answer in the evening. So the millennial is demanding. The millennial wants instructions and answers right there. You will note that this, an example of, I've seen from the poll that we have quite a number of in-house lawyers. The in-house lawyer is under a lot of pressure from his board to make sure that the services that they are getting from lawyers are within a certain budget, right? This in-house lawyer is under pressure to look good to their managers, to their board. And if they can get a law firm willing to partner and walk a journey of efficiency and make them look good by ensuring that they can access these services as fast as can be done, then those in-house lawyers will choose that law firm as a partner. So it's a key determinant of what type of work you will get and how much the clients want to offload to your desk. With respect to having millennials, even as staff, I know traditionally as law firms, we've always thought of the model where we have 8 to 5 working hours. We have offices that are confined and made of wood, if not wood, then very well partitioned. The millennial just wants to be able to work from wherever they are, right? So we are now having to shift our expectations of the advocate we are working with from seeing them to looking for the results that they are bringing. And corona virus has actually demonstrated that it's possible to still get results from wherever they are. So the world belongs to the millennials, and whichever law firm does not understand that will then struggle both at the point of serving the client and at the point of looking for human resource from these millennials. So I think for me, the millennial is currently the one dictating the market, and we have to listen to them and fashion our services and our law firms around what makes them happy. Yeah, that's what I would say, Katie.
And I think for you, Kamende, this heralds the arrival of the virtual law firm, you know, and what we used to call the briefcase law firm is now the gadget law firm. And I wonder whether we are now prepared for that. But coming towards the end of this conversation, perhaps one last poll, just to get a feel of what we all think. What do we consider to be the greatest drivers of change in the delivery of legal services? What do we see as the greatest drivers of change? Is it the advancements in technology? Is it client demands? Is it economic recession, competition, regulation? What do you think is the greatest driver of change? Interesting. I think a number of attendees attributing change to advancements in technology. So, Ongoya, does this, I mean, if this poll, even before we end it, would be anything to go by, would this be informing what we are teaching, curriculum changes, and perhaps having more emphasis on teaching lawyers tech?
Thank you, Kezi. Let me share with you a very interesting episode. Less than 3 weeks ago, students of the Kenya School of Law took the Kenya School of Law to court. They were challenging the decision of the Kenya School of Law to mount online classes. Now, you see the paradox there. They found that the court itself had moved technology, so that suit had to be filed online. So I laughed and wondered how a judge who himself is conducting a hearing online would question why another institution is mounting classes online. That's number one. Number two, the students raised a lot of logistical issues about use of technology, the weak internet connectivity. We all face it once in a while, dithering internet and so forth. And but they themselves had mounted this challenge against the school online using technology. And I was consulted by the lawyer acting for the school. Sometimes the school acts through its own lecturers on a pro bono basis. And I was laughing and telling the school, you know, the best argument you must advance is that if the court were to grant these orders, it will be frustrating your ability to mount practical classes on use of technology. So that by using technology in mounting routine classes, you are actually training future lawyers on use of technology, which will then enable the court move its service of technology more seamlessly than if the courts were to encounter advocates who are trained on paper, and the court has to take on the task of training them on how to log into a portal before they begin the litigation work. So I would say many schools, Strathmore Law School, where Kwenjera comes from, is mounting its classes this semester online. Kabarak Law School I come from is mounting its lectures online fully. As I participate in this seminar, I just got a notice on my phone informing me to take note that exams will be mounted online. So I mean, that tells you something, that we are moving online. Whether we are doing it well, we trust that experts in the ICT sector will constantly return us back to track. Because again, we are lawyers. It's the way you use your phone. You use it purely because somebody has told you this is where you press and it calls. Whether that is the best way or the most efficient way to use it, there's another expert, another professional who will tell you these are the cutting edge skills in the use of technology. So we are trusting that that partnership between the legal fraternity and the ICT world will continue and will be enhanced. I can tell you this for free, courts are going to employ more ICT technicians than clerks. Or clerks have to move to becoming ICT experts or just ship out. The way banks move technology using ATMs and other skills, and if you're a teller, you had to, move with it or just ship out, as it were. There's no room for being oppositionist to the place of technology. I think the academy is doing its best within its limited means. Whether we are doing our best in terms of global trends, we hope that those who are better placed in terms of knowledge of global trends will continue auditing us and telling us what we can do differently to enable us up our game. Otherwise, we will have no option to hope to think that because I can mount a class on Zoom, then I am doing well. Because I can transfer my assignments to Moodle, then I'm doing well, and so forth and so on.
Mm-hmm. Thank you, Ongoya. Allow me to seek your indulgence, our panelists and our attendees, to push our closing time by just 10 minutes. From now, we have 4 minutes to the close of the webinar. I'm just requesting that we extend by 10 minutes. Kamenda, there's actually a couple of questions for you here. What is the LSK's involvement in guiding liberalism with checks and balances? And if you could take that question together with this next one, the fact that advocates in Kenya are barred from practicing in other jurisdictions, don't you think that hinders business relationships that would spur growth in the legal profession? Perhaps you can take those two questions, Kamende, even as we begin to wind down and think through our call to action.
Kezzy, I lost you on the second question. You could repeat the first one.
Okay, so the first question has to do with the role of the LSK in guiding liberalism with checks and balances for our profession. And the second question is the fact that Kenyan advocates are barred from practicing in other countries. Don't you think that hinders business relationships that would spur the growth of the legal profession in Kenya?
Thank you. Thank you, Kezzy. The role of the Law Society is specifically provided for under Section 4 of the Law Society of Kenya Act, number 21 of 2014. And key is to facilitate trainings and also to guide the practice. And in involvement of the liberalization with the checks and balances, the Law Society has been actively participating in formulation of policies and laws by the houses, that is Parliament, currently. So the LSK follows up on legislation that in any way affects our practice. So we monitor legislation as the society through the committees. We have a committee that constantly monitors legislation so that we ensure that we do not have our spaces more shrinked or bottlenecked by the houses. That is in one way that we make sure that we are involved in the process of liberalization. The other way we do this is to review all the existing laws. We have currently started reviewing all the laws that require advocates as members. So I think the members of the society that are here have been receiving emails advertising in one way or the other that the county governments are now establishing this committee and they would require membership from the society. We do that, of course, putting in place the interest and welfare of our members. So that is how we get involved. We also get involved in these checks and balances. Of course, we follow the Advocates Act, the rules and regulations. We formulate regulations, and currently we are formulating rules on LLPs. So we regulate the society's the membership practice in law by also formulating our internal rules that govern the practice of law. I would also point out that we carry out CPDs, and we are currently reviewing the course, with the COVID, we no longer can do physical. Then we need to factor in the different and new areas that are not taught by Ongoya and Co in school, but now that require our attention as a regulator. So we currently partner with other stakeholders like KEPSA and also like yourself to provide and impart knowledge on our members. That's what I would say on that point. Well, on the issue of practicing lawyers, allowing our members to practice, if I got the question right, outside, it's not us per se that do not do that. Borders must be open. Like, I cannot wake up here, go and practice in Tanzania. We cannot also, as a regulator of practice of law, allow Tanzanians to come and practice in Kenya, because they do not allow us. That I had seen a question from one of the participants that we already have a shrinking space. So can we then allow members of the states that do not allow us to practice there come to practice in Kenya? This is where I said that there's need to pick up this discussion on opening up of the cross-border practices, because it's a practice that is governed by reciprocation. So Law Society may not do much on that because we cannot open up our space by incorporating foreign law firm practice in our act to member states that do not also allow us to do that. But it's a discussion that I think now it's inevitable given the emerging trends of practice of law.
Thank you. Thank you very much, Kamende. There is a question to you, Ongoya, and I doubt that we have sufficient time to address it. Advice, this is from Teresia Memia. What advice would you give to a lawyer who wants to advance in tech but has no experience? We might not be able to very specifically address that question. And I would like to ask you, Ongoya, instead to perhaps give what would be a closing remark and a call to action.
Thank you so much. So let my closing remark be a response to that question. Let's shift our attitudes for the better towards technology. Let's be receptive of new technologies. The rest will fall into place. Thank you, Kezi.
Thank you. Mukiri, any call to action? Any final remarks?
My final remarks, Kezi, are for us as advocates to treat the client as king. Other industries have already done that, probably 5-10 years ago. I think it's time as a legal fraternity that we recognize that the client is king and created a culture in our law firms that then supports the fact that the client is king. Once we get the client right, then technology will be something we must do because we have to serve them well. Once we get the client right, then it means that the school and the regulator must come up with ways of enhancing our client management skills. So for me, client is king for law firms if we are to bridge the gap between the profession and what the industry is demanding. Thank you, Kezi.
Just as we come to you, Christine, AK, your hand has been raised up. I'm not sure whether you wanted to make any comment or whether your question might have been answered in the course of this webinar. Christine, your final thoughts and a call to action?
So maybe just to say the ultimate goal for a client is wealth creation, and also from a public policy perspective is to raise enough capital in order to render the services. Having in mind that the client's ultimate goal is wealth creation, he's looking for partners who will provide business solutions to enable them create solutions. So for us as legal practitioners, we need to stop looking at our services as professional services, but as business solutions. That doesn't mean that we need to change our focus from being legal to something else. No, we just need to offer those services which are legal in nature, but driven at providing solutions. Having in mind, with that approach, I actually see us taking back services that have been taken away from us before. It actually creates more opportunities for the number of lawyers that are coming out into the market. And I think we will be in a better space to sell our kind of services. Thank you.
Thank you very much, Christine. Caroline, Kamenda, any final thoughts? Any call to action?
Yes. My final thought is to my fellow lawyers that technology is here with us. The future is virtual. The future is tech. And in the legal tech world, things are changing very fast at a very rapid speed and faster than many lawyers realize. It is therefore inevitable that legal tech will largely shape the way that the law is practiced in the country. To the law society, we have no option than to change the legal framework to embrace the changing world in the field of practice. Thank you.
Thank you very much, Caroline. I must thank each of you, our panelists, for your time this afternoon. It is 7 minutes past the hour, and unfortunately we have to wind up. We have to come to the close to what has been a very interesting 2 hours of conversation. You wonder how quickly time flows when you're having an interesting conversation. We definitely look forward to continued engagements. I want to thank our attendees and participants as well. Thank you for the many questions. I know that there are a number of questions that we have not been able to answer. There was particularly a question on billing, whether we can afford to continue billing as we do, even in the current global recession. But I do hope that we will continue with such engagements. Like I indicated, we will have a webinar coming up on law, innovation, and technology, and delving deeper into issues of cybersecurity and the threats around utilization of technology in law firms. As we come to a close, we are just asking for your feedback, even as you exit. Feedback on the relevance and the impact of today's discussion. We just want to welcome you to leave your feedback in the form of a poll. Let us know whether the conversation has been relevant, whether it has any impact in your practice or in your profession, or whether it is something that is not relevant at all. We are keen to know and to take your feedback in the survey. Once again, thank you. Thank you very much for your time. It's been an awesome 2 hours. We appreciate your time. So thank you. We have about 97% of today's participants saying that that today's conversation was relevant and timely. And I guess we must give it up to our panelists for the great insight. So thank you very much, Caroline Kamende from the Law Society of Kenya and from the African Bar Association. Asante sana, Christine, my friend, Christine Kahema Muthoi from Alpha Tax and Business Advisory Services. Thank you, Elisha, the only one I know whose name is Elisha Zebedi from Kabarak University. And of course, Vincent Mukiri, Managing Partner, Mukiri Global Advocates. And Dr. Peter Kwenjera, who had to step out to attend a meeting with the Senate. Asanteni sana. Have yourselves a good afternoon.
Thank you. Thank you, Kezi. Thanks for having us.
Thank you. Thank you.
Thank you. Good afternoon.
Good afternoon.
Asante. Good afternoon.
Good afternoon, Kezi.
Good afternoon.